If you have no criminal history, never been arrested, maybe never even got a parking ticket before, and suddenly you find yourself having been arrested for domestic violence, potentially facing a felony, what do? Of course, you're going to turn to an expert. You're going to hire an attorney. But not every attorney is the same. There are 5 essential things that can be the difference between having a felony record and potentially getting your case dismissed. In this video, I'm going to be going through exactly what those 5 things are, as well as giving you examples of how it could play out. My name is Veronica. I'm a domestic violence defense attorney. I help people throughout the entire state of California put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish exactly how to represent yourself and win your restraining order hearing. So if that is something you're dealing with, in addition to being arrested and dealing with this criminal case, make sure to get your free first class in the course via the link down below. Okay, so let's jump right in. Those 5 essential things that an attorney needs to do in a domestic violence case. Number 1, provide clear guidance from the start. Your attorney should be giving you clear instructions pretty much as soon as they get on your case. They should be sending you to things like anger management, domestic violence classes, therapy, couples therapy, depending on your situation and depending on how much time there is before the first court date. This shows that you are taking responsibility and moving in the right direction. A lot of attorneys don't do this. It is different when you are representing a gang member or someone accused of murder versus somebody who got arrested for domestic violence for the first time and has no criminal history or minimal criminal history. Not all attorneys understand that, and sometimes they use a cookie cutter approach for all criminal cases, which is not how you get the best result in these domestic violence cases. If someone is a gang member accused of assault with a deadly weapon, sending them to therapy or anger management probably is not the right way to address the situation. Not so for domestic violence cases. Showing that you are proactive can actually make a big difference to the prosecution. It's not an admission of guilt, and in fact, if you go to therapy or anger management classes, your attorney can keep those records and only use them if they want to. They don't have to be turned over to the prosecution. So there's basically nothing to lose by doing this, and potentially a lot to gain. So let's go through an example. John hires an attorney named Jerry to help him with his case. Jerry immediately tells him, "You need to start online therapy now." John thinks about arguing with him for a little bit, thinking it's not really necessary and especially not so urgent, but he follows Jerry's instructions and he enrolls in the online therapy. Jerry then contacts the prosecution before court and convinces them to drop the case, explaining not just all the good things about John, but also explains that he's going to online therapy. Prosecutors love this. The prosecutor says, "I was on the fence about this one, but you know what? If he's under the care of a therapist and he's being proactive like this, then I think we're probably not going to see him back here again, so I will give him a second chance." Meanwhile, Brian, unfortunately, he hires Saul as his attorney. Saul does not contact the prosecution before the first court date and charges get filed. Months down the line, Saul is talking to the prosecutor, trying to get the case dismissed or reduced. And the prosecutor says, look, he hasn't shown any initiative. He hasn't gone to any domestic violence classes, no anger management, no therapy, just nothing. And Saul tells Brian, sorry, look, you didn't take any initiative here. You haven't gone to any kind of anger management or therapy or anything. Brian thinks to himself, you never told me to. You're my attorney. Ultimately, at that point, it is too late for him to start taking therapy to show initiative after the DA is the one who suggested it. And Brian ends up with a conviction on his record. Number 2, highlight your positive background. A skilled attorney will gather details about your background to cast you in the best light. They'll emphasize your career, your character, and either emphasize your clean record if it's clean, or have some sort of explanation for your record if you have one. Look, part of criminal defense is fighting cases at trial. It is poking holes in the prosecution's case. It is filing motions with the judge. It's cross-examining police officers. The other part of it, though, is being able to tell a story about your client, to explain who your client is as a person. The DAs are only human. They are going to go hard on certain people that they think are really bad guys. For a domestic violence case, if they think that this is not the first time that any of this happened, if they think that you'll probably be back again, maybe having done something even worse, then getting a result where you keep a clean record is going to be very difficult. On the other hand, if they see that you are a normal person who maybe just had a bad night, or there was a misunderstanding or a false accusation, someone like them, and of course DAs, prosecutors all think of themselves as normal, maybe we all do, if they can relate to you, if your situation is understandable, then they are much more likely to give you an offer that could be a dismissal or something that will allow your life to not be derailed and protect your future. Let's jump into our examples. Sarah hires Jerry to help her with her domestic violence case. Jerry gathers many details about her family life, who she lives with, what she wants to do in the future, her education, her career, and is able to, when talking to the DA, cast Sarah in a good light. Ultimately, he's able to show the DA that she is just a normal person who just got caught up in a bad relationship and a bad situation. And Jerry is able to secure a dismissal that keeps Sarah's record clean and allows her to move on with her life. On the other hand, we have Mark, who unfortunately has hired Saul as his attorney. Now, Saul does ask Mark what he does for a living, but he only asked him so that he could figure out if he could charge him more. Saul doesn't even write it down. When Saul is talking to the DA and the DA asks Saul what Mark does for a living, he says, I don't know, something with computers. Mark can hear and see this from across the courtroom, and he feels embarrassed. And worse than that, he feels helpless. The DA can see that Saul is not going to put in the time to launching a strong defense, so the DA goes full speed ahead and refuses to offer him a dismissal. Number 3, contact the DA early. A good domestic violence defense attorney will contact the DA as early as possible before your first court date to try to get them to drop the charges. This is very different than a murder case or a gang case or a gun case. In those cases, there is no point and no time to contacting the DA early about dropping the charges. For domestic violence cases, though, it's different. So many people get arrested for domestic violence every day, and the DA's office cannot possibly prosecute all of them. You saw how quickly those arrests happen. They have to figure out who to prosecute. Therefore, it is very important to contact the DA before court and attempt to persuade them not to file charges. If we can drop it before court, it is better than winning at trial because you avoid all of the uncertainty, all of the time, all of the expense of trial. So a lot of criminal defense attorneys don't do this because they treat all of the cases basically the same way, but domestic violence cases are special. And I hear all the time from potential clients, from people who do have an attorney and had that attorney before court, but now if the court dates are happening and things aren't going that well, I hear from them that their attorney told them before the first court date that they should just wait, and that they should do nothing. Let's just see if charges are filed. That approach does not make sense, and it makes me frankly a bit angry sometimes that there are attorneys out there saying that, because now once charges are filed, they've missed that opportunity. Now it's going to be that much more difficult to try to get the case dismissed and keep this person's record clean. So let's jump into our examples, but this will be very quick. Jennifer hires Jerry to represent her in her domestic violence case. She hires him about a month before court. He contacts the DA as soon as possible with all the good things about Jennifer, with proof of all the different proactive things that he's had her doing, and the DA decides to drop the charges. Jake, unfortunately, he hires Saul. After watching a YouTube video, Jake actually asks Saul about contacting the DA early, but Saul waves him off and says, "Don't worry about doing any of that. We'll just wait and see if charges are filed." Jake, feeling like he has no choice, trusts Saul. Charges do get filed, and Saul's next step is trying to convince Jake to take a deal that would leave him with a felony conviction. Number 4, prepare the case as though trial is happening, even if it's not. Now, this applies if charges do get filed. If charges get filed, your attorney should be preparing the case as though it's going to trial, meticulously challenging the allegations, the DA's case, preparing a defense, and filing motions. Look, the DA has about as many cases as the public defender, sometimes more depending on how their office in that particular courtroom is set up. A very well-prepared attorney stands out. One thing that I like to do for all of my cases is always get transcripts of the body-worn video. The body-worn video is where the police officers are wearing cameras, and it contains the exact statements that everybody made, which is really important for a domestic violence case. Usually it is different than the police report, but attorneys like Saul, they don't do any of that. And I'm going to lend Jerry a story from a recent case. After getting arrested for domestic violence, Dan hires Jerry, as his attorney. The police report doesn't look good for Dan, and Dan, unfortunately, he didn't hire an attorney before the first court date, so he has been charged with a felony. Upon taking the case, Jerry immediately gets body-worn video transcripts of all of the body-worn video showing exactly what the alleged victim said to the police officers when she was accusing Dan of domestic violence. Now, one of the things that made this particular case a felony is that the alleged victim had a bunch of cuts on one of her legs. In the police report, there's an altercation vaguely described in which Dan attacks the alleged victim, and there are photos attached to it that show these pretty bad marks, pretty bad looking injuries on her leg. Now, when Jerry talks to the DA about the case, and Jerry is trying to get the case dismissed, his client's willing to do some anger management, but they really want to get the case completely dismissed. Otherwise, Dan, to protect his future, he'll just have to go to trial. The DA almost laughs as he tells Jerry, look, I'm not going to dismiss this case. Look at her legs. That's a pretty bad injury. In fact, maybe we should add a great bodily injury allegation. That's an enhancement that would cause more prison time. In response, Jerry pulls out the body-worn video transcripts and he shows the DA that the alleged victim actually never said that Dan caused those injuries to her leg. The police asked her about the injuries to her leg. She never responded to them, and they never asked her again. Also, when watching the body-worn video, which Jerry has on his phone, ready to show the DA in a very convenient way, all queued up, you can tell that the victim is obviously drunk. So what happened here? My theory is that the victim was drunk, she tripped and fell, and that's how she got that injury. The DA can see how much of an uphill battle he's going to have at trial, and he gives Jerry exactly what he's asking for: online anger management in exchange for a complete dismissal. Mickey, on the other hand, he is represented by Saul. Saul barely reads the police report, let alone watching the body-worn video or getting any transcripts of it. And when he talks to the DA, and the DA laughs and says, look, what about the marks on her leg? I'm not going to dismiss the case. Saul says, okay, what about felony probation? Saul goes back to Mickey and he tells him victoriously, hey, I got you felony probation. You were facing 4 years in state prison and I got you this great deal. Mickey now, because his attorney is not prepared, is faced with the choice of taking a felony that will ruin his future or going to trial and potentially, if he's convicted, going to state prison. Number 5. Be relentless and never back down. This is a big part of criminal defense and of domestic violence defense. If you want to get the best possible outcome for your client in this type of situation, and the DA is being stubborn, you need to be very clear about what you are not willing to accept. For example, if you're not willing to accept a conviction, be very clear about that. Be very clear about what you're willing to do. For example, community service, classes, whatever. And then fight. Show them that you are not willing to back down. Explore every possible avenue. So some examples of this are talking to the DA supervisor, setting up a meeting with the DA supervisor, sitting down with them and discussing this. So this is somebody who, depending on the county and depending on the courthouse, generally is responsible for the lower level DAs. And you can talk to this person and get a better deal in the case potentially. What about filing motions? Every time you file a motion in a criminal case, the DA's office has to either accept whatever you're trying to go for, or they have to respond. And they can see that you're fighting. And if they want to be stubborn, then they're going to have to work for it. So Steve hires Jerry for his case. Charges have already been filed, but Jerry is trying to get the case dismissed. If Steve has a conviction, it is going to seriously derail his future. But the DA won't budge. They are insisting on probation and a conviction. So what does Jerry do? He sets up a DA supervisor meeting and he starts evaluating the case to see what motions could we file here. Okay, did Steve say something to the police without being read his rights? Maybe they have a bunch of other evidence they could potentially use too at trial, but if he did, then we're filing a motion to suppress. He talks to the judge about the case and the judge starts pressuring the DA because the courtrooms are backed up and the judge wants to avoid having cases go to trial unless they have to. Eventually, Jerry keeps setting more court dates. And ultimately, Jerry's efforts pay off. And the DA says, okay, what do you guys want? You want a dismissal? If I give you a dismissal, he's going to have to do 20 hours of community service. Jerry has already talked to his client about community service, and Steve readily accepts it. He does his 20 hours of community service, and at the next court date, the case is dismissed and he has a clean record. Rachel unfortunately had Saul at the first court date, and charges are filed because we know that Saul didn't do anything before court to try to get the case dropped. Rachel sees the DA give Saul a Post-it note. The Post-it note contains Rachel's offer. Remember, this is the very first court date. Saul has just received the police report. He does not have any body-worn video. He doesn't have anything. He goes over to Rachel and he says, all right, I got you a deal. You were facing 1 year in jail. Now I got you 3 years of probation instead. You can do the 3 years of probation and then get it expunged. This is the best you're going to get. You should take this. They're going to take it off the table. If you don't take it today, when we come back, it will be jail. Rachel, not having anyone to turn to, accepts that deal. This happens every day. If you see an attorney get a post-it note at the first court date and try to get you to take that deal, that attorney is not advocating for you. They're just trying to close your case as quickly as possible. They have not looked at the body-worn video. The DA hasn't looked at the body-worn video. Nothing has really been done on your behalf at all. And almost guaranteed, if you had the public defender and had not hired Saul, you would have gotten that exact same post-it note. I hope you found this video helpful. If you do have a domestic violence criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find the video helpful, please don't forget to like, subscribe, and ring the bell.